Hello there and welcome back to the Disability Law Show. Good to have you around for another week. John Scholes here, James Fireman right there, disability lawyer, of course, at disabilityrights.ca. We always kick off every show with the contact information. It's usually a good plan to reach out to James anytime. Consultation's free, so pick up a phone. Use it, 1-855-821-5900 and help at disabilityrights.ca. To back it up with an email. Always have questions, emails, phone calls, main topics. It's a busy half hour. This week it will be top questions clients ask about disability claims. James will be handling that for sure. And as always, James, you kick it off with something you want to bring up off the top. Pal, what do you got going on this week?
Well, I think it's a good time to talk about long COVID. Now, long COVID has been around in the public consciousness for several years now, of course, and there is a lot of confusion about how someone who's suffering from long COVID fits into the whole disability insurance scheme. So let me start by being really, really clear about one thing. If you have long COVID, and that is preventing you from being able to work, you're entitled to disability benefits. You have a group benefit policy, you have long-term disability, and you're suffering from long COVID, it's preventing you from working, you are entitled to long-term disability benefits, full stop. Now, here's the issue, of course. With acute COVID, if you have a COVID infection, there has been testing around since the very early days of COVID, we know that. So you can determine yes or no if you have it. It's not 100% perfect, but certainly you can get a positive test and be able to prove objectively that you are suffering from an acute COVID infection. But whether you're suffering from any symptoms of long COVID afterwards is still very much a mystery. Now, much smarter people than you or I have been spending years working on figuring out a test to be able to determine that, and I don't know how far along they are. What I do know is that there isn't anything widely available that can confirm whether or not you are suffering from long COVID and whether or not the symptoms of long COVID are having a very specific impact on your life. So where does that leave you if you're not able to prove that you have it? Well, the reality is, for long-term disability benefits, you do not need to have objective medical evidence of your condition in order to be entitled to benefits. And when you think about it, that's obviously the case. If you're suffering from a mental health issue, there is typically not going to be any objective test that shows that you have depression, that shows that you're suffering from anxiety. It is by nature subjective. Long COVID, while not subjective, cannot be proved at this point widely with objective medical evidence. And so because of that, it is something where the insurers have the ability to say, well, you don't have objective medical evidence. And that sounds as though that's a valid reason for denying a claim.
Sure.
But again, to be really, really clear, it is absolutely not a valid basis to deny a claim. If you take a look at your policy, and if you are anywhere in the disability process, that is a very good starting point. Whether you're applying or whether you've been approved, you should have a copy of your policy and understand exactly what is in there. And when you look at your policy, and you look at the definition of totally disabled under the policy, you will not find anything in there that says that you are required to have objective medical evidence. It's just not there. And yet the insurers will lean into that. They will say, well, you know, you have asserted that you have long COVID and your doctors say that, but there's no objective medical evidence and we're going to deny the claim. And so this is something that we see all the time. The courts have said very clearly you do not require objective medical evidence in order to be entitled to benefits. Now, they have not said that in the context of long COVID, and it's not because it isn't true for long COVID. The reason no court has ever said that you don't require objective evidence to be entitled to disability benefits if you have long COVID is very simple. There's not a single long COVID case in Canada that has ever gone to court where a judge has had to make a decision on it. It's never happened. And that's not an accident. The insurance companies do not want long COVID cases before a judge, and the reason is pretty straightforward. As soon as there is a decision by a judge in a long COVID case, the judge will absolutely confirm that long COVID is a compensable condition under a long-term disability plan. There's no confusion about that. It clearly is. But once a judge has confirmed that, then there is an open floodgate. everybody who has suffered long COVID, and some will be illegitimate. There will be illegitimate claims in there too. But everybody who's got a legitimate claim, and a lot of people who don't, are going to say, well, I have long COVID. That means I can actually get my LTD benefits. I'm going to apply. And that's going to cost the insurance companies millions and millions of dollars. So how do they approach it? Well, when you apply for benefits, they will deny those claims out of the gate, because the more they deny, the less chance they're going to actually have of having to pay those out down the road. The only way to do it, if they deny out of the gate, is to start litigation. So you find in a lot of cases, even though someone has confirmed acute COVID cases in the past and they've gone to their doctors, they've been sent to specialists, even if they've gone to a long COVID clinic, they are still very frequently denied their LTD benefits, even though there's really no doubt that they are suffering from issues that are preventing them from being able to work. We see that all the time. They get denied or they get cut off very quickly. They say, okay, well, we'll give you treatment at this clinic for 8 weeks and then you should be ready to go back to work, as though somebody has found the key to unlocking long COVID and getting you back to work. It hasn't been done yet. And so the reality is it's all bogus. But as soon as you start litigation, as soon as you say, okay, well, we don't accept what you're saying, I'm entitled to benefits, and if you're not going to be reasonable, I'm going to go in front of a judge. As soon as you do that, you hire a lawyer, you start litigation, the insurance company's posture changes immediately. It goes from, okay, well, long COVID, you need objective evidence, we're not going to pay, to, okay, let's be reasonable. Let's talk about how long you're likely to be disabled for. And we see this time and time again. So if you are suffering from long COVID, and if you are not able to work as a result, do not believe that you're not entitled to benefits. Apply. If you're denied and they say, well, you don't have objective evidence, don't accept that. Give us a call. It's a free consultation. And as long as you have support from your doctors, that does not mean objective evidence. As long as your doctors are supporting that you are suffering from long COVID and you are following whatever reasonable treatment guidelines are suggesting, then you're going to be entitled to benefits. And if we have to start litigation, that's exactly what we'll do.
So if that one case, James, eventually did get to court and eventually did come out with a positive outcome for the person who's suffering, would we all know about it? Is it a matter of, because I don't know how legal stuff works, is it a matter of public record? Is that what the insurance companies are fearing? That all of a sudden, like you said, the floodgates will open, right?
It is certainly a matter of public record. So every reported decision in Canada is publicly available. Anybody can access it. There's actually an online database called CANLI,
wow.
CANLII, and you can look up every reported decision. I think it goes back to 1994. So they are certainly freely available. Now, whether it's on there and people are going to know about it is the other question. But I really strongly believe as soon as there is a reported case, that is going to be picked up by news outlets across the country and reported widely. And as soon as that happens, floodgates open.
And that's what the insurance problem. That's where they have the problem. They're going to start paying. Right?
100%.
Wow. Wow. Pocket Disability Lawyer, you ever use this? PocketDisabilityLawyer.ca. It's basically a series of questions you go through. How it functions. Do you need James on your case? Do you need him to help out with you? Go to PocketDisabilityLawyer.ca. It takes about 30 seconds to do it. It's anonymous, really helpful tool. And again, it's free. You can use that anytime you would like. We get questions all the time in the radio shows across the country and coming into us on the phones as well. James is here to answer them. We're all here to listen to them. So the first question for the show today is coming up. Have a listen.
I'm on LTD, have been for a year and 5 months. The insurer is now forcing me back to work. I submitted a doctor's letter to them saying I'm not ready. They dismissed it and said that because I did their recommended rehabilitation program and some back to work help, I didn't qualify. Can they dismiss my case like this?
It's a really interesting question. It is something that we see all the time. And for context, there's one thing that this listener said that I really bumped on here, and that she's been on LTD for a year and 5 months. So what that means is that she's coming up on what we call the change of definition. So in a standard long-term disability policy, when you go on medical leave and you apply for benefits, your disability benefits, there's typically a waiting period. Sometimes it's 3 months, sometimes it's 6 months. There's some period of time before your LTD benefits become payable. Once they start paying you, the test is whether or not you're suffering from a disability that prevents you from doing your own occupation. However, that test changes after 2 years. It changes to whether you have a disability that is preventing you from doing any occupation. And so when you're getting close to that period, when you're coming up on that 2-year mark, and she's been on claim for 1 year and 5 months now, so she's about 7 months out from this change of definition, that is consistent with when we see insurers starting to try and get their ducks in a row and trying to find ways to bump people off claim. And so one of the ways that they do this is with rehabilitation, as they've tried to do with this lady as well here. And so the issue for the insurance company is that once they have agreed that you are disabled beyond 2 years, once they've agreed that you meet that test, that 2-year test, which is you're disabled from any occupation, it becomes a lot more difficult for them to subsequently say that you're no longer entitled to benefits. And so they really focus in those last 6 months before that 2-year mark at looking at ways to find to cut you off of the benefits. And so that they have started with this rehab program isn't surprising. Now the rehab program is typically going to be run by a clinic that is not directly affiliated with the insurance company. You won't find, they're not going to be owned by the insurance company, but they're getting a lot of work from the same insurance company. They know who is paying their checks. And so there is a lot of inherent bias in that system. First and foremost, because they want to keep getting the business, they want to make the insurer happy. And so how do they do that? Well, by saying, okay, we've completed the program and they're good to go back to work. There's also another bias there too, which is that they want to show that they've done a good job. They want to show that, oh, well, they've been with me for 8 weeks and I'm a really valuable person. I'm really good at my job. And so these are all the ways that this rehabilitation has helped this person out. And we see when we get the insurance file, we get these records from rehab facilities, and it's very common to see they'll have 8 or 9 metrics that they'll track over the course of the rehabilitation program. And invariably, a couple of them are going to improve over time. They probably would improve anyway, even if you did nothing for a lot of things. But not all of them do. But when you see the final report will only focus on the metrics that got better. And somehow all of the things that either stayed the same or, in many cases, actually got worse during the rehabilitation are completely ignored or explained away because of lack of effort or some other reason where there's really nothing underlying that. So the fact that the rehabilitation may be saying that she's ready to go back to work isn't terribly consequential to me. That her treating doctors are saying she's not ready to go back to work is very significant. She's still within the 2 years. So the test hasn't changed. And if her doctors are maintaining that she can't go back to her own occupation, there is clearly a very valid basis to challenge it, which is exactly what she should do here. Free consultation, we take a look at what we have, and as long as there is that medical support, there is going to absolutely be a good basis to challenge that decision.
Yeah, the doctor thing is one of the 2 things I didn't like in this. They just totally dismissed what the doctor said, which is a big no. And what exactly you mean they're forcing me back to work? That sounds a little bit physical. Like,
well,
what does that mean?
So I bump on that too. The reality is they're never actually going to force you back to work. Nobody is going to come to your house and put a gun to your head and say, you have to go back to work. That obviously isn't what's going to happen, but they will put you in a position where it's incredibly difficult for you, and depending on your financial circumstances, it may, for all intents and purposes, be forcing you back to work. Right. Because if they're saying we're stopping your benefits as of this date, we expect you to go back to work, and you're relying on those disability benefits to pay the mortgage, to put food on the table, what choice do you have, even though your doctors are saying you should not do it? That's a practical reality of the situation, and there isn't a great solution for that other than to give it a shot and white knuckle it through. But if there's any way to avoid that, if you can follow your doctor's advice, that's exactly what you should do. Start litigation and take them to task.
We got to get into a quick break. When we come back, the main topic, which is top questions clients ask about disability claims. That is on the other side, right, as we continue more of the disability law show. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. but we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back to the Disability Law Show. Thank you for joining us once again. John Scholes, James Fireman, disability lawyer, always reachable, 1-855-821-5900, help at disabilityrights.ca. Time for the main topic, James. Top questions clients ask about disability claims. Number one is this: how long can I stay on LTD disability benefits?
I know this one. It's an easy question.
Good.
It's actually one that you can typically figure out on your own.
Right.
Again, first step, always take a look at the policy. So for a typical disability policy, you get it through your group benefits plan. You're almost always going to see it pays you up to age 65, but that's a maximum. Of course, it can be shorter than that if you stop meeting the definition of totally disabled under the policy. So we've talked about the test, whether you have a disability that's preventing you from doing your own occupation. What is necessary is that you have a continuous disability from the time you go on leave up until benefits are payable, typically called the waiting period. Again, it could be 3 months, 6 months. So you have to have a total disability during that waiting period and then a continuous disability thereafter. And as long as you have that continuous disability, you'll be entitled to benefits up to a maximum of typically age 65.
Is this consistent through all policies, through all insurers?
So for the most part, yes. It's a pretty good rule of thumb. If you are looking at a private long-term disability policy, or policy that perhaps you bought outside of your employer, something that you wanted to insure for yourself, or if you're an executive, there can be some variance there. I've seen policies go up to 70 or 75. It's very unusual to see anything other than 65 if it's part of a group benefits plan. It's possible, but it's unlikely. There are situations where the end date can be earlier if you have a pension that is paid for by your employer or contributed to by your employer. Then it is not uncommon to see language in the policy that will limit the end date to whenever you're entitled to a full unreduced pension.
Yeah,
certainly that's true with teachers. It's also true with a lot of other unionized employees. Yes. And there may be other situations as well. So you do want to be careful about that. You want to make sure that you understand when that end date is. But again, that's typically something that you can discover simply by looking at your policy.
Second question: what does total disability mean in a long-term disability policy?
Oh, this is one of my favorite questions,
I know it is.
as you well know. So, total disability is an industry term, and it's used quite intentionally. When you say the word or the phrase total disability, it conjures up an image in your mind of somebody who is incapable of taking care of themselves in any way. They are totally disabled. You think of somebody who's totally disabled as being somebody who really can't get out of bed, that can't bathe themselves, that can't feed themselves, that can't put clothing on, that has difficulty with every aspect of their life. That's what we think of when we think of total disability. That has nothing to do with the definition of total disability in a disability policy. In a long-term disability policy, total disability simply means that you have a medical condition that is preventing you from being able to do your own occupation, or beyond 2 years, any occupation. That's what it means. You can absolutely qualify under a LTD policy and meet the definition of totally disabled, even though you can get yourself out of bed, you can make meals, you can go for walks, you can even do some volunteer work. There are all sorts of things that you might be able to functionally do that you still may not be able to do your own occupation. It depends on what is your occupation and what is your disability. You may be able to do a lot of things physically, but if you have a mental health issue, you may not be able to do an occupation that's very high stress. Or if you have a cognitive issue, you may not be able to do a job that requires very high executive functioning. Or if you have a physical issue, you might be able to do, some sort of sedentary job, but if your job is physical, what good does that do you?
Right.
So there are a lot of things that you might well be able to do, but still meet that definition of totally disabled. So just because the insurer is saying that you don't meet the definition of totally disabled, don't read into that as being, well, okay, I can get out of bed and make myself scrambled eggs, so I must not be totally disabled. No, that's not the way that it works.
Wow.
It has a very particular definition. And if you're at all unclear about what it means and whether it applies to you or not, give us a call. Free consultation. We're happy to go over it. We'll take a look at what your insurer has said and what your doctors are saying and get to the bottom of it.
Third question, last one, is what medical evidence do I need to support my disability claim?
That's an open question, and that is very much a case-by-case thing. So what you want to show is that you have done everything reasonable to get proper medical attention. So typically, that's going to start by going to your family physician and reporting whatever the issues are on a reasonably regular basis. And then your family physician from there is typically going to refer you to whatever specialists are necessary depending on your condition. If it is a mental health issue, typically a psychologist or a psychiatrist. If it's a physical issue, somebody who specializes in the particular area that you're having physical problems, whether it's an orthopedic surgeon or a neurologist or a gastroenterologist, whatever the case may be, it's your family doctor who's going to direct that. And then that you're following up and you're taking whatever medications are prescribed and that you are following through with whatever treatment measures are recommended by your treating doctors. That is the medical evidence that you need to support it. And typically it is very helpful if that includes a diagnosis and something that specifically addresses whether or not you can work. However, typically that's just not what you're going to find, or at least the latter part, you're not going to find that in the medical records. Doctors usually do not turn their mind to whether or not your condition is preventing you from working. Sometimes they will, especially if you raise it with them.
Right.
But when you see your doctor, they're typically just wondering about your medical condition and trying to treat that. They're not necessarily looking at it in the context of what are you able to do in the rest of your life.
Covered. One more short break. We'll get to another phone question and an email and possibly more if we have time as we continue more of the disability law show. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. A few minutes to go. I want to remind you each and every time that you can reach out to James and his team. The consultation is free, or it's just a chat. You need that too. Same number, 1-855-821-5900. Help at disabilityrights.ca. We'll get to an email in a minute here, but I got another phoner question. We call it a phoner question, James, in the business, but it's basically an audio question. Let's listen to it right now.
I've submitted letters to my insurer from my doctors, and they keep asking me for more info, but my doctors have told them everything there is to know. I really don't know what else they'd need at this point. Can they delay my claim like this? I haven't been paid at all for months.
Doctors love that.
Yeah, so can they delay the claim like that? So to a certain extent, sure. I mean, insurance companies are allowed to do their own medical investigation, and there can be a reasonable basis for them to say, okay, we're not convinced right now, we need more information. There are circumstances where that might well be a legitimate position. Doesn't sound like that's the case here. It's not sounding like it. taking the caller at their word, at face value. If the doctors have submitted everything that they have and the insurer isn't paying, they're holding back, or they haven't made their decision yet. And I don't think at this point they've made a decision. It's not really clear. But if they haven't made their decision yet, at a certain point, you're just going to say, all right, I'm taking this as a denial. And you're just going to ask them to finalize their decision one way or the other. That's what I would do at a certain point. Because if your doctors have already provided everything that there is to provide, and they've confirmed that with you, and the insurer still hasn't approved, then there really isn't anything else to do. What I will tell you is not helpful at all is having your doctor go back and write another letter that says the same thing, but it's just pleading like, I already told you everything that you need to know. This person's clearly disabled. What are you doing? Right. I've seen those letters from very well-intentioned doctors who are absolutely frustrated and confused as to why the insurance company hasn't approved their patient's claim, and they don't do anything. The letters themselves, unless they're providing new information that fundamentally changes the way the insurer sees the file, and by fundamentally changes, I mean like, oh, this is caused by cancer. I'm not talking about like, no, you don't understand what this test result means. It means it's really bad. It's got to be something more than that. It has to fundamentally change the way they view the file. Short of that, we really don't see any additional information changing anything if they already have everything. Right. So there's not a whole lot that you can do at that point. And if the insurer hasn't approved the claim, then they're telling you what you need to know. And so what I would do in that circumstance is I would write to the insurer and I would say, we don't have any more information. The doctors have provided you everything. Can you please confirm your decision as soon as possible? And if they don't respond to that, then I would look at starting litigation. Absolutely. There's no reason to wait at that point.
Quick email. Here we go. Christine says, my insurer wants me to go to some sort of discovery. I'm suffering from PTSD due to a traumatic event. My psychologist has said I shouldn't go into details as it can be difficult or triggering, but I'm worried about what they will be asked or what I'll be asked. If I refuse to answer certain questions, will they cut off my LTD?
This is a really tricky question because certainly insurance companies are entitled to know information about your situation, especially if we're talking about a mental health issue. And so it's reasonable for the insurance company to have questions that they want answers to, but only to a certain extent, and that doesn't necessarily mean that any form of questioning is okay. So for example, it's reasonable for your insurance company to want to understand what your day-to-day activities are like and how you get through each day. It's not reasonable for them to ask you that every day by phone. That is not reasonable. There are limits to what they can do. And at a certain point, it becomes harassment. And the interesting thing, John, is that I see pretty typically this is done much more frequently with claimants who have a mental health issue, especially anxiety. Claimants who have anxiety, they seem to have a lot more interest from the insurers in terms of what their day-to-day activities are. Is that because they're vulnerable? Is that because putting them in that situation is going to aggravate their condition and cause them to give up? You can draw your own conclusions about that, but you see enough of it and it seems to be pretty obvious at the end of the day. Mm-hmm. What I would do in this scenario is if the psychologist, if Christine's psychologist really feels as though the process that's being suggested by the insurer is harmful, it's really important that the psychologist put that in black and white, let the insurer know exactly what their position is, that this is harmful, and if she's forced to go through with it, this is what the result is going to be. Wow. That may not cause the insurance company to change their view, but at the very least, it puts you in a much better position down the road if you need to start litigation.
Christine, thank you so much for that email. That is it for this week's show. Again, reach out to James and his team anytime. We said it before, the consultation will not cost you a dime. Just call the number, use the email, 1-855-821-5900, help@disabilityrights.ca, and we will catch you again next week. Thank you so much for watching.